Okay, we have three cases on our calendar this morning. First up is 221279, Carlton and Harris Chiropractic versus PDR Network LLC. Mr. Hara, whenever you're ready.
Yes, Your Honor, thank you. And may it please the Court. Glenn Hara for Carlton and Harris Chiropractic, Inc. The District Court erred in dismissing this case on the basis that a fax cannot be an advertisement, as that term is defined in the Telephone Consumer Protection Act, unless on its face, within the four corners of the document itself, the fax, quote, offers something for sale, close quote, to the recipient. That's at A45 of the appendix.
Do you agree that there needs to be a commercial nexus, at least, for the advertisement?
No, Your Honor. Our primary argument is that this fax is an advertisement.
And what case law do you have that supports your position that a commercial nexus isn't required? Because I haven't seen any.
Well, it depends on commercial nexus. If you mean a pretext to future advertising applying the 2006 FCC rule, then there are cases, plenty of them, applying that rule or at least adopting its reasoning and getting the plaintiff past a motion to dismiss. That's what the only other Circuit Court of Appeals that's addressed this question did in Physicians Health Source versus
If we
Behringer.
give deference to the rule.
It didn't defer to it. It agreed with it. The Second Circuit said, we agree.
That's beyond deference.
Right, and at the pleading stage, you can't require a plaintiff. It's a catch-22, Your Honor. The plaintiff in Behringer couldn't know what happened at the free seminar that was advertised, but it was plausible at the pleading stage that this for-profit pharmaceutical company advertised its drugs at the seminar. The same thing is true here. I can't know what is in the 2014 ebook. I've never seen it. The district court's never seen it. This court's never seen it. And I'd suggest there's a reason why they don't want us to see it. But I can't allege what's in that book because I just don't know. And I'm in the same position that the plaintiff in Physicians Health Source versus Behringer was in.
I'm sorry, can I just, but your position is that's not a commercial nexus.
Well, I think that is a commercial
Then why
nexus.
are you arguing that you don't need a commercial nexus?
Because my primary argument is that
Right, and I'm saying how come? Like,
Under-
I understand why that was your primary argument, whatever it was, many moons ago when we first heard this case.
Many faxes ago.
Right, because at that point, right, you hadn't amended your complaint to allege a commercial nexus. Now you've alleged a commercial nexus, so I guess I'm having trouble understanding why your primary argument is that you don't need a commercial nexus.
Because the plain language of the statute says an advertisement advertises
Why did
the
you amend
quality
your
of property
complaint?
goods.
Why did you amend your complaint?
Well, because it's a belt and suspenders argument. We wanted to, if a pretext is necessary, we wanted the facts in the complaint to show that there's a pretext. We also had more information at that point. PDR Network submitted the only thing that we could call a factual record in this case, which is a one-page description of its services, of what it does. And it makes clear that PDR Network sells healthcare products and services to healthcare providers like my clients. Even if they're not explicitly doing so in this fax, they have things that they can sell. So they're unlike, for example, the defendant in Physicians Health Source, Sandusky versus Medco, the Sixth Circuit case, where the defendant was a pharmacy benefits manager and it couldn't sell anything to the plaintiff if it wanted to. It didn't have anything for sale. Here, PDR Network sells interactive drug information services, digital communication services, behavior-based prescription management programs, all kinds of things to healthcare
What about the
providers.
fact that on the fax itself, the only place where healthcare products and services are mentioned is in the opt-out at the very bottom?
Right. It tells you are going to continue receiving faxes about healthcare products and services from PDR unless you opt out. It's what the FCC calls a negative option, where the sender presumes your consent unless you tell them otherwise. The fact that it's in fine print at the bottom of the page, I think, is legally irrelevant, as the Seventh Circuit held in Holtzman versus Terza. Judge Easterbrook there said, what part of any do you have trouble understanding? Any material advertising. The fact that 80% of the fax in that case was informational and only 20% was advertising was irrelevant in that decision.
Counsel, can I ask you about that? Because this is the basis for like your pretext argument, right? Pretext to a sale. But I thought, the pretext language is somewhat confusing to me. But if we're talking about like a prelude to a sale or something, I thought those were cases where the idea was that the free thing being offered, like a seminar or a catalog or something, would then be sort of leveraged. Once you take the free thing, they'll leverage that to make a sale. Like you give me a free e-reader, and then the next thing you know, you're sending me advertisements for ebooks. But here, this is like the opposite. This is saying take it or don't take it. Forget the volume. One way or another, we're coming back to you unless you opt out. So this case seems really different to me because the product that's being described isn't going to be used in any way, leveraged in any way to make a later sale. I just don't understand how, like just saying in a fax, if you don't opt out, we're going to sell you stuff. I guess I'm just not understanding how that fits into that line of cases.
Well, first of all, we don't know what happens, what PDR does when somebody accepts a copy of the...
I understand, but this is a different allegation, I thought, that, but go ahead.
Right, but PDR does have things to sell to the plaintiff. So I'm just saying that's different than the cases where summary judgment was granted in Medco. At least they got some discovery into what the defendant did. We've had no discovery whatsoever.
Okay, so if you're relying on it just for the fact that PDR sells stuff, that's one thing, but
And they're telling you you're going to get future advertisements. unless
whether
you
or
opt
not
out.
you take the volume.
Correct.
Okay.
Unless you opt out. But let's say you do accept the free 2014 ebook. We don't know what follow-up happens after that. We don't know what's in the 2014 ebook. I think it's reasonable to presume, although I can't allege it, that PDR advertises those healthcare messaging services, interactive drug information services in the 2014 PDR ebook.
And the district court found all of this way too attenuated. So what is your response to
The
that?
district court held, it's a pretty radical holding, Your Honor, that the fax itself, within its four corners, has to try to sell you something in order to be an advertisement. The statute doesn't say that.
That doesn't sound radical to me, but carry on.
Well, the statute doesn't say that. The statute says an unsolicited advertisement is any material advertising the commercial availability or quality of any property, goods, or services. It doesn't say anything about attempting to sell. It doesn't say anything about it having to be the sender's property, goods, or services that are being sold to the recipient. It's a very broad definition. And all the authorities PDR is relying on, and the district court, place these artificial additional words into the statute that aren't there, like commercial quality, for example. The district court wants to read it as commercial availability or commercial quality of any property, goods, and services. I've argued below, and I argued in my brief here, that that's redundant. Commercial quality is the quality of being commercially available. It means the same thing as commercial availability. And PDR Network really hasn't meaningfully told us what the difference is there or why we have to stick that extra commercial word into the statute. It
Can I ask
doesn't
a
belong.
follow-up about the scope of the pretext theory that you're espousing? So I think you're suggesting that pretext at least reaches the ability of PDR to later leverage the facts to sell other products that you don't know what they are because they aren't in the book. But I thought I recall, and this case has been around for a while, so maybe I'm just in my worst nightmares remembering something that's incorrect. But I thought I recall an argument that the pretext reaches as far as perhaps a kickback from the drug manufacturers who advertise the products in the book. Do I have that right?
That's right. We expressly allege in the complaint, in the amended complaint, that PDR is compensated by the pharmaceutical companies based on how many copies of the 2014 ebook they distribute. So PDR Network stands to profit. Their profit turns on how many, that's the language you use.
And how does that fit within what the district court found to be the unambiguous text of the act? In terms of commercial, and the like.
It provides the commercial nexus because PDR, we allege, is being compensated based on whether it can persuade people to accept this 2014 ebook or not. Now, I want to note, PDR Network will probably argue that we failed to make that argument in our brief, but that's not true. At pages 20 through 21, we argued, of our opening brief, we argued that because the facts relates to PDR Network's for-profit business, if this court adopts the Second Circuit's rationale in Behringer, the facts would be presumed to at least plausibly be an advertisement at the pleading stage, and we say that's consistent with this court's ruling in the first appeal that it is, quote, certainly plausible that the amount of money PDR receives turns on how many copies of the physician's desk reference it distributes. So we did make that argument. We've made it all along. And I don't know that it's really disputed, but I mean, PDR admits that they are compensated by the pharmaceutical companies whose drugs are listed in the physician's desk reference. I think that's undisputed. I don't know if they've admitted that they get paid more each, based on how many copies of the thing.
Did you make that argument in the district court?
Yes.
And what did refresh my recollection, how did the district court, if at all, address that?
It held that that's too hypothetical because it's not in the fax itself. There has to be an offer to sell something to the recipient in the fax itself. It's a very strict interpretation that the district court gave it. Most courts at least allow for a pretext theory of liability in theory, right? The district court in this case wouldn't do that. It has to be in the four corners of the fax. Notably, PDR Network doesn't defend that rationale in this court. PDR Network says at page 26 of its brief, to be an unsolicited advertisement, the fax itself must make a sale or be so integrally part of an attempted sale as to render the fax effectively a pretext to a solicitation. So PDR Network concedes that you can, at least in theory, have a pretext theory of liability for a TCPA junk fax violation. The district court opinion in this case disagrees with that. It contradicts that.
Can I ask you, sort of on a different area of your argument, where you argue about the 2006 rule, right? Your first argument, even though you've alleged a commercial nexus, is you don't need one under the 2006 rule. Do you read that rule, which we have construed as this kind of per se prophylactic rule, do you read that rule or the commission as saying that the statute doesn't require a commercial purpose or nexus? Or is the commission saying that the statute does, and because it will so often be present in cases where people are offering free goods or services, will prophylactically assume it's present in all of those cases? We're just kind of weighing the ease of enforcement and clarity, those benefits, against the fact that it might actually be somewhat overbroad.
I think it's the second one, Your Honor.
Okay, I do too. But then let me ask you this. If it's the second one and we're under Skidmore, I'm not sure how deference works, because we're not under Chevron anymore. We're just trying to construe the statute. And the commission, as I think we agree, wasn't exactly construing the statute. It was sort of saying something different, that even if the statute requires a commercial nexus, we're not going to make people prove it up in every case because we know it's going to be there in 99.9% of the cases. Do you see what I'm saying? I'm just having trouble with your Skidmore deference argument.
I think the commission was construing the statute. And the part of it that it focused on, I think the key to it is what it focused on was the quality of property, goods, or services. These things are presumed to advertise the quality of property, goods, or services, even though they don't advertise the commercial availability of property, goods, or services. They advertise the quality.
But your first answer to me was, but the commission understands they don't always. They just almost all the time do. They almost all the time will have a commercial nexus if they are promoting the quality of a good or service. But they won't always have the commercial nexus.
But they don't always, I agree.
Okay.
And the commission recognized that in the presidential who's who decision that PDR Network relies on. It recognized in footnote 20, I believe, that more broadly, the 2006 order says faxes offering free goods or services are advertisements under the TCPA. But it didn't have to apply that broad rule in the presidential who's who, because there was a record. They can show that it was a pretext, that there was follow-up after somebody said, sure, I'll be in the presidential who's who. Then they started getting other solicitations for things that did have a cost, that weren't free. So I would like to say you only get to, I just want to be clear, you get to the pretext argument only if you find the statute ambiguous. And our first argument is that the statute is clear that faxes that advertise the quality of property, goods, or services are advertisements. And there's really no need to get any further than that. And the alternative, of course, is if you disagree with our reading of the statute, you disagree with our reading of the FCC rule and whether it's entitled to Skidmore deference, we would ask that the court follow the only other circuit court of appeals on this issue, the Second Circuit in Behringer, and hold that at the pleading stage, there's a presumption in place that the defendant can rebut after there's been discovery into the circumstances of the sending of the facts and what happened at the free seminar in that case, what's contained in the free publication in this case. Thank you.
Thank you. Thank you, Mr. Hara. All right, we'll hear from PDR Network. Are you ready, sir?
Yes, may it please the court. My name is Kweku Okoa. I represent the PDR entities. And I'd like to start where Mr. Hara left off with the text of the statute. Now that we understand that the FCC didn't promulgate a rule, didn't create a separate legal requirement in the 2006 order, we really are talking here about what scope of liability is created directly by the statute. And I think the core of that statutory requirement, the core of that scope of liability, is the word commercial. We know that from the text and also how the Supreme Court has construed a different definition in the same statute. We know it from the congressional findings that underpin the TCPA, and we know it from the underlying constitutional framework that Congress was pointing to. So to start with the text, the phrase commercial availability or quality, every court that has construed that language has understood it in the way that Mr. O'Hara objects to, as saying that commercial modifies both availability and quality. And the Supreme Court in the Facebook versus DeGuid case just 2 years ago, construing a different definition in the TCPA, 227A1 versus 227A5, said when you have a concise, coherent phrase like that, so there the phrase was store or produce, here availability or quality, a modifier runs through both halves of that, and that's a natural understanding of the phrase. So I think that Mr. Hara's first textual argument really runs up against the plain language of the statute.
Right, so counsel, assume at least hypothetically that I think, yeah, there's some commercial, what we're talking about has to be commercial for it to come within the statute. So I think you say this in your brief, commercial means relating to or involving the buying and selling of goods. So I don't understand then why this wouldn't be covered. This is a fax that promotes a reference volume that is allegedly at least funded in part by drug companies and that lists products that drug companies sell. It seems like that would be related to the buying and selling of the funding drug companies' products.
Well, so funding drug companies'
Yeah.
they're not funding the drug companies.
The drug companies that allegedly pay extra for every volume that is sold, or every volume that is placed.
Sure. So
Yeah.
I think where the particular understanding of commercial that the court should have, and again, I think this is the understanding that's been applied as a matter of consensus, is derived first from Congress's findings in the TCPA and then the underlying constitutional framework, as I said. So in Section 2 of the Public Law 102-243, you have a set of express findings which are codified as a note to Section 227. And what Congress is pointing to is our reasons for adopting the TCPA are that Americans are getting buried in solicitation calls. Those are revenue-raising calls, more than $435 billion. So they're worried about that.
Well, but this is a revenue-raising call, fax, as alleged, for every volume they place, they make more money. It's PDR's business model.
So Congress went on.
Yep.
And what they said is we have an understanding of where the First Amendment framework comes into play. So this is in Section 2, sub 13. We have to distinguish between commercial calls and non-commercial calls, consistent with the free speech protections embedded in the First Amendment of the Constitution. And then in sub 8, they said the Constitution does not prohibit restrictions on commercial telemarketing solicitations. So what understanding of commercial is Congress bringing to the table here? It's the one underscored just 2 years before that, and many times since by the Supreme Court in Board of Trustees versus Fox. The heart of commercial speech is the offer to engage in a commercial transaction to buy and sell. And then the court goes on to say Because there it was talking about a policy that extended beyond. So there were some buy-sell transaction offers that were in play, but also others that were motivated by profit. And what the Supreme Court said, I think
I mean, Judge Harris's example is exactly that, isn't it? This fax is motivated ultimately by some profit down the road.
And that's what I'm coming to. Here's what the Supreme Court said. While these examples consist of speech for a profit, they do not consist of speech that proposes a commercial transaction.
Well, hang on,
which is
because
what
I understand that, and
Yeah.
that is why, like, even in the 2006 regulation, I think they do bracket out. They say, look, it can't be anything that you send with a profit motive. If you're sending like an industry newsletter to generate goodwill that you will later use to make a sale, that's not covered. But this has to be describing the quality, promoting the quality of a product. You have to be saying, this is a great product, and you have to be saying that with a profit motive. So that's different from anything with a profit motive. This is a pitch. Take my product. My product is great, and I am making that pitch because I will make money if you take my product. Why would it care? What in the word commercial tells me that it matters whether I will make money from you, the recipient of the product, or from some third party who will give me the money if you accept my sales pitch?
So my next answer is that that's exactly how the FCC has construed exactly this statutory phrase, unsolicited advertisement, for purposes of the robocall provisions of the
To
statute.
defer to that one.
Well, so the commission, looking at what Congress has been focused on, has consistently, I think this is the difference, consistently across time said if the communication is about an over-the-air free program, it's not an advertisement. If the communication is about over a cable for pay for service communication or program, then that is an advertisement. And they've been very clear because I think the commission is looking at this line that the Supreme Court has drawn in the commercial speech area, where they said many of our most important and high-valued items of speech are motivated in a sense by profit. But what they don't do.
What about the Second Circuit case that appears to go against your position?
So I think Behringer is really distinguishable. I mean, Behringer is a case where you have a company that has its own products, and then invites people to a seminar, and they said, okay, and this is a seminar possibly at least about a condition and possibly about the particular drug they sell. So I think to come to the pretext point, Judge Harris, I think you're exactly right. The notion of pretext, the word itself, pretext, tells us it's about disguise. So we have a two-step program in which the first
So in the
step.
Second Circuit, it was
Yeah.
less attenuated than, the connection was less attenuated than it is here, which is what the district court apparently found.
Yeah, I think that's right. The two-step was quite clear, or at least was inferable from the allegations. The two-step was step one, we invite you to what appears to be a free seminar, but step two, you walk into the seminar and it's a sales pitch. That's the pretext two-step, I think, as the Second Circuit understood it. Here,
Counsel, when you were describing Behringer, is it important, and it seemed like it was important in your brief, that it has to be the sender of the fax's own products that are going to be sold at the end of the day? Is that a limit you want us to adopt?
I think it makes it clear in those circumstances why the Second Circuit saw it as a two-step. They said, it's your seminar and it's your stuff.
Yeah.
But I think the more important point here is the question the colloquy you engaged in with Mr. Hara about, well, so wait, what is it that the opt-out is supposed to do? What is it that the allegation that in the back there's some exchange of funds? And I'd like to come later to why I don't think that's very plausible. But none of that has to do with a two-step. None of it has to do with you ostensibly get.
I mean, the statute doesn't say it's only commercial advertisement and covered by the act if it's a two-step, right? I mean, commercial enterprises are fairly ingenious and think of all kinds of different models by which to promote their products. But, I mean, why would the statute be that limited?
Well, so pretext is already, I think, way out on the edge of the statute. And that's why the Third Circuit has suggested that pretext is not a valid theory. There's a case before the Seventh Circuit right now, a case called Tallman. Seventh Circuit is considering, their decision hasn't come down yet, whether pretext is a valid theory at all. And most of the cases that have accepted it out of the context that we were in previously, where what everyone thought was that the FCC had promulgated regulation. So that when you look to the regulation, you can look to the text of it and it says pretext and you can go from there. So now we're back to the statute. The statute, I agree, doesn't say anything at all about pretext. I think to try and fit pretext within what we do have in the statute, which is a requirement of commercial transaction in the constitutional sense, you do have to be pretty tight. Otherwise, you just have what the Third Circuit described in Mouthy versus National Imaging Associates. You say, well, just kind of everything becomes pretext because in your mind you can sort of say, the hip bone is connected to the thigh bone. And that's clearly not what Congress was going for when it said, we want to combat this abuse of advertising, but we also understand that we are constrained by the Constitution. We don't want to cross those lines. So where do we want to go? We want to focus on commercial transactions. And we know what the heart of that is. The Supreme Court has told us. Commercial means proposing a commercial transaction, buying or selling. So I think that's how we get there.
No, you go.
So what First Amendment speech principle is being vindicated by the facts in this instance?
So it doesn't. The question isn't whether there's political speech. It's just that the Supreme Court has distinguished between commercial speech for transactions, easier, more scope for the legislature, for Congress to regulate, and non-commercial speech.
But you seem to have in mind something. So you think what Congress thought was under the First Amendment, all we can regulate is a direct offer of a product for sale. There has to be a direct offer. Because I don't even know what case that was that Congress was thinking of. I know the cases you mean about, it's the heartland, blah, blah, blah. But is there a case that says if it's not a direct offer of a product for sale under the First Amendment, you can't touch it?
No.
Okay.
I don't think Congress was saying we can't touch it.
Okay.
Because they can't, there's heightened scrutiny, and sometimes statutes can survive heightened scrutiny. But what Congress was saying was, we know that we have more scope when we're regulating commercial speech.
Right.
Right? And if we get outside of that frame, we know that there are lines we can't cross. And the ordinary constitutional avoidance framework tells us the courts infer that Congress doesn't want to go near the lines. And here you have Congress saying it quite directly, because again, otherwise you just have, I think, a kind of unconstrained, basically the per se rule that Mr. Hare has been arguing for.
Let me just ask this.
Yeah.
So let's say we were to disagree with the district court and decide that, the statute says what it says, but the plaintiff should be allowed some discovery to figure out exactly what the motivations are regarding this facts. And let's say it turns out that your colleague on the other side is correct on both points. That is, that the facts, that PDR, in fact, has products that it wishes to sell, which are identified in the book itself, and that PDR also gets money in whether you call it a commission, a kickback, whatever, from the drug manufacturers for placing their products in the book. Would that be covered by the TCPA if that turned out to be the case?
Well, so first, I think it's important to talk about what's been alleged and what hasn't been alleged. There is no allegation that there's anything other than the FDA-approved full prescribing information in the ebook. In fact, that's what is affirmatively alleged through the copy of the facts itself. That what is contained, this is their pleading, same trusted FDA-approved full prescribing information. There's not one word in the complaint that suggests that there's something else in there.
Okay, so what if they had pled that? I know that you're saying that's not this case, but if they had pled that and discovery turned out to support that theory. Is that a violation of the TCPA?
I think that I think it would depend on what, but I think I can imagine a circumstance where you'd say that the complaint says, on its face, it says, all we're sending you is the FDA-approved full prescribing information. And by the way, I think it's important to understand that the FDA doesn't just approve the prescribing information in a vacuum. It does it as part of the new drug approval process. So the drug can't be entered into interstate commerce until FDA has reviewed and approved the prescribing information. Also, that the format, content of the prescribing information is closely regulated by
I'm not sure you're answering my question.
Yeah, I apologize, a little bit of a detour. If the facts was like this, it said what you're getting is the full prescribing information, and then the allegation were, it turns out if you get the ebook, it's full of glossy ads. I can see that. I think that's the two-step. I think that then is, it looked like it was not an advertisement, but it turned out that it was, and in fact, it was promoting sale. So I can see something like that, but that's not alleged anywhere here.
Can I ask you, would it matter in that case if the ads were for PDR products or for drug company products?
I think if the ads were for PDR products, then you'd really be close to the Second Circuit.
What if it were for drug company?
For drug companies, I think maybe that's a step harder, but I can imagine, and it would depend on the exact nature of the pleading. But certainly, sometimes there are middlemen who stand in and they hawk for somebody else. Yeah, so I think
it's the sender's own products, so it doesn't really matter.
I think it would be clearer, but it sort of depends on the allegations. And again, you don't have that.
So I actually want to
here
take
at
you
all.
back to your
Yeah.
detour. When you say that the complaint only alleges that it gives you the different case, the FDA,
Different case, I agree.
the FDA prescribing information for drugs. I mean, it does list the drug, right? It says, here's a drug, and here's how you prescribe it, right?
Yes.
I mean, that's the allegation, I'm sorry.
Yeah, well, that's what, I mean.
So it calls, you could understand it as sort of calling to physicians' attention. Here's a drug, like it's a Merck X, and here's how you prescribe it.
So one thing that I think is really important to understand is that in the process of approving this full prescribing information, FDA makes a determination that it is, quote, not promotional in tone. So that's 21 CFR 201.56A2. So it's not promotional,
But
it's
it lists,
pre-approved.
I
Yeah.
understand that the
So-
prescribing information is not promotional, but it is a book. I thought what was alleged is that it is a book that lists out a bunch of drug company products and tells physicians how to prescribe them.
Yeah, so here's what FDA says about what the full prescribing information is, and I think that's what's fairly alleged, is that's what's in the ebook. It is written so it reflects FDA's findings regarding the safety and effectiveness of the human prescription drug under the labeled conditions of use. The PI, this prescribing information, is written for the healthcare professional and must, 1, contain a summary of the essential scientific information needed for the safe and effective use of the human prescription drug, be informative and accurate and neither promotional in tone nor false or misleading, and be updated when new information becomes available that causes labeling to become inaccurate, false, or misleading. So it is the scientific
Yes.
backdrop.
Right, it sounds very
Yes.
dry. It is not a
Very-
glossy
it is-
advertisement.
And we provided a couple of links as examples in our
Okay.
brief. If you go to that, I think you'll say, this is nothing like people skipping through the meadows when I see a drug ad on
Okay,
TV.
but nevertheless, if I'm a doctor, as I understand it, the way I would use this volume, the way it has been alleged I would use this volume is, I mean, I actually don't know how doctors work, but, so I have a patient, this patient has a condition, I open it up and see what can I prescribe and how. And I will find in there a list of drug company products and how, in very, very dry terms, how they may be prescribed.
Yeah.
Okay.
I'm a doctor's son, so if I can say that with some pride. My father used to have the physician's desk reference on his desk every single year. It would come. It's a giant encyclopedia. And so what else is basically alphabetical? You find the drug, and it will tell you dosing information if someone's 17, if someone's 55, if someone's taking it, it's contraindicated. So under no circumstances take it if you have condition A in addition to condition B. If you have more than 3 alcoholic drinks a day, never take this or only take it if you're following blood work or the like. It's that kind of dry technical detail from the manufacturers to the physicians through the FDA's approval process.
Okay.
I see my time is almost up. I want to come back to what the district court said and I think didn't say. So I don't think the district court said you can never look outside the 4 corners. I don't read the opinion that way. I think what he's saying is, I've looked at this other information that's been provided, and it doesn't provide the kind of commercial nexus that would give rise to any kind of valid theory. I think the district court acknowledges a pretext theory. I don't think he comes down strongly one way or the other, but says, I'm looking at this information. It's very attenuated. There's an opt-out provision. There's some contact information. There's an allegation that there's an exchange that would have nothing to do with the recipient. I think this is the key point about the allegation that the drug companies pony up 4 cents each time a PDR goes out into the world, which I find hard to imagine. But that none of that has anything to do with the recipient. None of that makes it commercial in the sense of promoting a sale. And I think that's exactly the right way to understand this facts. The reason that he's standing here saying, I want a broad rule, is he needs a broad rule. Because if we're asking whether this fax sells something to the recipient of the fax, the answer is no. And Judge Chambers got there, he's gotten there twice. And I think that's the right answer. If there are no further questions.
Thank you, counsel. Mr. Harry, you've got some rebuttal time. Go ahead.
Yes, thank you. There was discussion about the Behringer case, obviously, in the Second Circuit. If you read that opinion, the reason the Second Circuit held that there was a presumption at the pleading stage, they got the plaintiff past a motion to dismiss on a free seminar fax, was not because the plaintiff alleged in the complaint that the defendant advertised its products at the free seminar. My law firm was counsel for the plaintiff in the Physicians Health Source case. I don't have that complaint in front of me, and I can check, but I can at least say that's not what the Second Circuit relied on. What the Second Circuit relied on was the arguments of the parties and its common sense, right? And the reasoning of the 2006 order, which the court agreed with, where it held, this is a for-profit corporation. They don't do things for no business purpose. It's unfair to the plaintiff because the TCPA is a remedial statute that we're supposed to interpret in favor of the consumer and not in favor of the fax advertiser. So since there's an ambiguity in the statute about whether free goods or services, faxes, or advertisements, we're going to resolve that, at least at the pleading stage, in the plaintiff's favor. And we're going to give the plaintiff some discovery into the underlying circumstances of the case. Just like what happened in the BPP case that the PDR network submitted as supplemental authority a couple of weeks ago. That was decided on summary judgment. The plaintiff got discovery into what happened in the case. Otherwise, it's a catch-22. I would be required to plead what's in a publication that I don't have access to. Only the defendant has access to it. Just like the plaintiff and physicians in Behringer didn't have access to the slides that were shown at the free seminar, for example. There's no way the plaintiff could have known that.
And what, in your view, have you alleged is in that volume that would make it commercial?
We don't know the contents of the 2014 ebook, so I don't allege anything about it.
Allege anything, so you're not, right, there's no allegation that it will contain PDR products or services?
No, but I think as in Behringer, that's a reasonable inference, that PDR network would not turn down that opportunity to advertise these other products and services that it sells to healthcare providers like my client.
You allege that PDR benefits or profits from the sale of the healthcare products and services referred to in the fax. But the only place healthcare products are referred to in the fax is the opt-out, which tells you how not to get this book. So I don't see how that allegation gets you there, since that you can't benefit or profit from something you're opting out of.
Well, it's telling you we're going to send you advertisements or information about healthcare products and
It's
services.
telling you we're not. The only place it talks about healthcare products and services is in the opt-out.
Yes. And it says, unless you opt out, we are going to send you more stuff, right? And we know from...
Opt-out.
Well, that's exactly what the FCC has rejected. That's putting the burden on the consumer. It's a negative option. You're saying it's okay to send to deluge the consumer with junk faxes unless they opt out. It's the burden's on them.
Is it, I still am struggling with what your claim is about the opt-out language. So is it your position, I guess it is, that if you get a fax that just says, tomorrow I'm going to send you an advertisement, the first fax was also an advertisement?
I think if it says, unless you tell me not to, I'm going to send you an
How could
advertisement.
that make
then
it
yeah, it's a
worse?
pretext.
So the first, it's just like, just get a fax tomorrow and it says, on March 20th, I'm sending you an advertisement. That first fax is also an advertisement.
I think
Because
it's
it's a pretext, it's not very pretextual, it just says, on the 20th, you're getting an ad. It's very upfront.
I think under the FCC ruling, that's a pretext,
A
yes.
pretext for what?
For advertising, for future advertising, or part of an overall marketing campaign, right? You're testing the waters first to see if maybe you can get some interest there. A lot of times, robocallers, they'll text you or call you, and when you opt out, they say, hey, we got a live one here, right? That means there's somebody listening on the other end of this line, so it's a good number, right? The FCC has encountered that.
So it does make it, so you're saying, maybe if it just says you're getting an advertisement tomorrow, it's not an advertisement, but if it says unless you opt out, you'll get an advertisement, then that might be part of a marketing campaign, because they're very interested in whether I will bother to opt out?
I think that's reasonable, yeah.
That seems crazy, but okay.
My time has expired. If there's no further questions, thank you.
All right, thank you both for your arguments this morning. Before we proceed on to our next case, we're going to come down and greet counsel.
Asking that dismissal from the lower court be reversed, the case be remanded, and frankly be reassigned. Because the court below granted defendant summary judgment just hours before we're about to file our opposition to defendant's motion for summary judgment and two Dabber motions to exclude the defendant's expert from having opinions for trial.
What would you have included in your pleading that you didn't get to pursue that wasn't already in your own motion for summary judgment?
Well, two things. One would have been testimony that we had from the defendant's witnesses, the director and the CEO, that was not in our opening brief, mainly, and I brought it with me because I think it's important. It goes to the negligence issue. And we asked the independent director, did you understand at the time that the actual metric for cash flow had not been disclosed? And he answered, I didn't give it much thought, but it wasn't there. I didn't see it. And then we followed up. Do you recall if there was a discussion as to what line item of projections to include in the proxy? Answer, that was management decision, not the board decision. And the management decided what to put in the proxy statement? He answered yes. And we deposed the CEO, Mr. Patrick, and we asked him, did you consider you personally what projections should be included in this document? And he said, no, I did not. And that's at A1168, which was not in our opening brief. And that would have shown the judge that we have evidence of negligence. He might have still not granted our summary judgment, the plaintiff, but certainly there was a genuine material dispute at issue for the jury to consider. And more importantly, our Dabber motions. We don't think the experts the defendants put forth were adequate. One of them, Mr. Foster, which is the one that introduces the idea of custom and practice, was a defendant himself when he was a board of director because they screwed up the proxy. They didn't put the right statute in Delaware statute for appraisal. And he's the person saying, I know how this should go. Well, I don't think so, because he himself made a mistake when he was a board of director.
So far you've been talking about things you would have put in going to the negligence question. Was there anything going to materiality or, misleadingness that you didn't have a chance to put into your opening?
I think what happened with materiality is also twofold. One, yes, we would have refocused because I think the court, reading the opinion, and I suppose after it read defendant's motion for summary judgment, came to that opinion, made a couple of mistakes, which are not the law. One, the state of mind. There is no mens rea in a 14A case. So we would have been able to focus that issue with the court to explain that.
Can I just ask you just one last question on this?
Sure.
The procedural issue you've raised. I do understand your argument that, by the time it all happened, it was kind of too late to object in some sense. But I guess I am thinking that if you had stuff you wanted to get in front of the district court, even after the fact, you could have objected or moved for reconsideration. It just seems very late to start this whole thing over so that the district court can read your, additional arguments.
The judge entered a ruling and closed the case. On PACER, you could see, case closed. I think we came to the conclusion we needed to appeal, and we were going to ask for reassignment because the judge below has clearly shown partiality to the defendants. And just to preserve the appearance of impartiality, if you choose to remand the case, which I think you should just on procedural grounds, even if you don't agree on the merits, I think we need to be giving a different judge that has not made up his or her mind before it reads our brief, which is what happened here. So I don't think it's fair to require us, well, even if you think you're going to lose because he's telling you you're losing, you should try to move for reconsideration because it's shown a complete disdain for this case. And I think it happened because he just read another ruling from Judge Hollander, I guess, in the Hurtado versus Gramercy property, but that case is very different. For one, they had cash flows disclosed. And for two, there was no discovery. And here we conducted discovery, and we learned. And we think we have a reasonable theory to present to the jury. They didn't disclose the cash flows because they had downwardly adjusted them significantly.
And how is that material or misleading?
Because if you're telling me to rely on Piper Jaffray's analysis to support the transaction based on a discounted cash flow analysis, which they did, and your numbers have been slashed by a third, and that's at 8,784. The 2022 numbers, cash flows in June 2018 used, were 13.5 million. The ones in November 2017 for the same year were 20 million. That's one third.
Did appellant consider the cash flow before
Yes.
voting?
Well, he doesn't remember how he voted,
He doesn't even know if he voted.
but he doesn't have to because there's no reliance requirement. That's the whole distinction between a 14A and a 10B5 case. There's no reliance.
So, and you can tell me if I'm wrong, but as I understand the law in this area, there has to be a material omission that renders what is said misleading, right? And I guess I am just not understanding how this description of the discounted cash flow analysis is in any way misleading, even if I assume that, even if I assume that somehow, like the bottom line number that they started from as their earnings estimates was material, and even if I assume it was wrong, it was too low, like all of this is still true.
Well, no, because the proxy essentially, it's sort of the defendant's opportunity to tout the transaction.
Yeah, but
And the
I
way
guess-
they tout it is they say,
Can you point me to the part in this description of the discounted cash flow analysis that is rendered misleading by the omission of the earnings estimates? All this says is we started with an earning estimate. It doesn't vouch for it. It doesn't say it was high, low, consistent with what happened the year before. And elsewhere, the same document says estimates are just estimates. We are not vouching for their accuracy. So all this thing says is we started with an estimate, the accuracy of which we do not vouch for, and then we did this to it, and then we did that to it, and then we did that to it, and then here's the number that came out the other end. All of that is true. It doesn't matter what the input was.
and then we give the board a fairness opinion. And they use that analysis to support it. And the board touts the fairness opinion. And the banker could have not rendered a fairness opinion if the cash flows were higher. That's the issue. And those are issues for trial. Those are not issues at summary judgment. And our expert said as much. And our expert testified, or opined, I should say, that he found cash flows would be material here. He also opined that the November 2017 projections were not stale and were the ones that should have been used. And the defendants moved to exclude Mr. Kidd's testimony. They filed a Daubert motion. The lower court did not rule on it because it said it was moot, because it ruled in favor of the defendants at summary judgment. But it appears it acted as if it was granted in his mind because he didn't rely on plaintiff's expert, only relied on defendant's expert, and didn't have the opportunity to review our opposition, not just to the summary judgment, but to the Daubert motion that was pending against plaintiff's expert. Procedurally, this case is a nightmare. I recognize that. But I don't want to stay there. I want to move on. And we do have, on the merits, 3 independent reasons to support reversal. On the materiality, we've talked a little bit about it. I don't know how I cannot convince you that if you are hiding the cash flows from the shareholders and you have manipulated them and you give that to your financial advisor to obtain a fairness opinion and the board touts this is a fair merger, how that's not material. And I think there's a great quote from the Northern District of California, the Grizzly case I think it's called, where it describes what an average shareholder or investor is, and it's a capitalist that wants to consider projections when assessing the value of its shares. And that's what we're dealing with here. We're dealing with capitalists that need to understand what their shares are worth. And when you lie to them...
Mr. Montefiore, let me ask this question. So is it, if there had been no earlier cash flow projections that back in November that you indicate are really important for a reasonable investor to know, if those had not existed, and all we're left with is a proxy that simply doesn't identify in the detail that you would prefer the cash flow analysis, it just ultimately renders a fairness opinion. That's a different case, isn't it? Or would you still have a problem?
I think that's a different case, and I think...
So what this case is about is really the earlier cash flow, discounted cash flow that wasn't disclosed to your client.
Well, I don't think it's like the St. Jude situation where they changed the theory of the case in the middle of the case. Here, we knew there was an omission. We prevailed at the motion to dismiss. Then we conduct discovery. At discovery, we were able to now figure out why the omission actually happened.
It sounds kind of like, if you're agreeing that the case that Judge Diaz hypothesizes is at least a very different case, maybe you shouldn't have prevailed at the motion to dismiss stage because that was the only thing in your complaint.
No, because it's a different standard. I think materiality at a motion to dismiss is a lower burden, and I think a pure omission, when you're able to allege you missed some big...
I mean, yes and no, like under the, I can never remember my acronyms today, but under the PLS...
BSLRA.
Yeah, right. heightened pleading standard, right?
Yes.
You actually have to plead exactly what you're talking about, and you don't, there's nothing in there about these, their cash flow estimates were lower than they are supposed to be because 2 years earlier they were higher. That's not in the complaint.
No, but there's an omission, right? And we had law rely on Delaware Chancery Court rulings like Merrick Capital that granted an injunction. And remind you, we sought an injunction. It was just not heard due to the schedule of the court. We originally moved to enjoin the vote because the cash flows had not been disclosed. There's case law that says that's material information. And certainly at a motion to dismiss, it's not unheard of that you're able to prevail. It's a lower standard, even with the heightened scrutiny that the PSLRA provides. But maybe you can say we got lucky during discovery to be able to really hone in on the issue, perhaps, or perhaps that actually is why they omitted the cash flows. And it makes sense that if you have cash flows that were higher.
Isn't the expert testimony undisputed in this case that nobody includes the numbers? Well,
No.
2 out of 88? You all dispute that? That's
We
disputed?
do. That's another problem. Mr. Keith actually says no. He reviewed many merger and acquisition transactions, and he found cash flows are mostly always included. Their expert focus only on banks.
Your experts had reviewed a number of proxy statements and found that this information usually was not included.
No, that's their expert.
Well,
Their-
I know theirs did too, but I thought that one of yours did as well.
No, mine the opposite. In fact, mine also testified or opined that he believes it should always be included.
Which one is yours that you're?
Mr. Keith,
That it should always be included, or it is always included?
should always be
Well, that's a
included.
different question, right?
No. Two different issues. He did opine that they're mostly always included. The defendants, experts said no, except they did an analysis of 44 companies, and even their own analysis showed one of them on one instance.
How did he define mostly always included? What does that mean?
Just mergers in general, and the defendants were focusing only on specific regional bank transactions. And we took issue with that because we said that is not an appropriate assessment. But even if you only focus on the regional bank analysis that the defendants expert did, in one instance out of 40, I think it was, or 44, there was a disclosure of cash flow. And again, that goes to, at least it goes to not supporting summary judgment, because that is at least enough for a jury to consider, should that be the one instance here also, or should it not be? That's a material question. I'll briefly touch on damages. I will say before I move to the issue of negligence, because there's some issue about the standard of care. That's usually in the jury instructions, and even on the exhibits that the defendants submitted with their summary judgment at Exhibit 26 and 27, you see it, the description of negligence and the standard of care. That is not something that experts normally testify on. The Shanahan case is different because that was a complicated tax and options issue. But on damages, the court below didn't follow Supreme Court precedent, which is Mills and Virginia Bank shares. And you have to break down the two elements, there's transaction laws and economic laws. And transaction laws really is the merger and the proxy used to get the merger approval, and the economic laws is the proximate cause. And the statute prohibits soliciting votes of shareholders with a misleading proxy. That's the conduct. And if the conduct is wrongful of the board of directors, then it's the proximate cause for the damages, which is receiving unfair price of the merger. And all we're asking this court is to follow Supreme Court precedent and even your own precedent. Back in 1989, this court had Virginia Bank shares before it went to the Supreme Court. And there it required a plaintiff to establish three things: that the proxy omits or misleads a material fact, that defendants are negligent in drafting the proxy, and that the proxy causes injury. We have those elements, we have alleged them. The court below rushed to granting judgment for the defendants, and it didn't consider the plaintiff evidence, and we ask that the case be remanded and please reassigned so we can have an impartial judge consider this matter. Thank you.
Thank you, counsel. Mr. Long?
Good morning, and may it please the court. My name is Robert Long from Alston & Bird, and I represent the appellees in this matter. Plaintiff can't prove the 14A element, so he has tried to reduce the 14A claim to a single element, that all he has to provide evidence of is a material omission. That's not the right test. Every circuit that has considered that has rejected that test, and this court should not be the first to adopt it. Instead, under the applicable law, plaintiff has to show that the alleged omission is materially misleading, that there was loss causation, and that there was negligence. There are three key points in the factual record that are undisputed and demonstrate why plaintiff cannot meet any of those elements. First, plaintiff has no loss causation evidence, none. That is, plaintiff has no evidence that the omission of the cash flows or even the merger caused any economic harm to plaintiffs, to the First Connecticut shareholders at all. Second, plaintiff has no evidence establishing that the merger proxy failed to provide a fair and accurate summary of the work performed by First Connecticut's financial advisors. That's all that Section 14A requires. But even if you wanted to look beyond that and ask yourself the question, were the omissions misleading? There is no evidence, even by his own expert, that that is the case. So, third, plaintiff has no evidence that defendants breached the standard of care that an ordinarily prudent director would have used in similar circumstances. That is required to demonstrate negligence. So each of those independently would be enough to justify dismissal in this case, and he doesn't have any of the three, so summary judgment is the right result. So I'd like to now turn first to loss causation. In Dura and Stone Ridge, the Supreme Court said, look, if you are a private plaintiff and you are going to be seeking economic damages, economic recovery, then you have to show that the violation you're alleging showed economic loss. That's what they say. It's a pretty basic common sense element of a claim. And in the wake of that, courts have realized that, yes, while Mills is out there, and Mills says that, that if a transaction goes forward by a misleading statement, that can be transaction causation. We also have to consider loss causation as is set out by Dura and Stone Ridge. So transaction causation is one thing that does need to be considered, and then loss causation also needs to be considered. Now, plaintiffs argue that we should ignore Dura, that we should ignore all the circuits that have found that there's both transaction causation and loss causation. But I mean, I don't know what to say about that. The Supreme Court law is clear. He argues that, well, Dura was limited to 10B claims, and this is a 14A claim, and that's totally different.
So, counsel, I mean, I did look into this a bit. This actually seemed like kind of, sorry, but like the law was not 100% clear here. Why are we starting here?
I'm happy to talk.
Do we have to resolve what looks to be at least somewhat of an open issue?
I'm happy to talk about any of the three elements you want to talk about. I think that the loss causation issue is so clear under the established law and the precedent and the other circuit's rulings that you don't even have to reach the other
You started by saying there's no loss causation. There's nothing you can trace to this hypothetical misrepresentation, and there's also no loss even if you just have to show that the loss was caused by the transaction, by the merger.
I'm not arguing.
Which one do you want us to do?
I'm not arguing that transaction causation is not met here. I'm only arguing that he is not tied any, when he's seeking economic recovery, he has to tie the alleged omission to an economic loss. And there's no evidence of that here.
It has to be a link between the omission itself and the loss.
Correct.
What if you only have to show that the merger caused a loss?
Well, I mean, that would, you be saying that Dura doesn't apply for some reason?
But could he show that here?
No. Well, oh, I'm sorry. Could he show that he has transaction causation?
You've lost. Can he show that, are you conceding that if all he has to show is that the merger caused financial loss, he can show that here?
Yes, he can show that. All right. So back to Dura, and I'm going to continue with my loss causation points unless you all just want me to move on to materiality or negligence. Back to Dura. He argues that Dura shouldn't apply because the loss causation is only with respect to 10B claims. But that's not what Dura says. Dura says that under the PSLRA, which is 14A is part of, you do not have to, you have to show loss causation when you are a private litigant. And that is exactly what we have here. So Dura applies, and Dura also notes that you have to be able to show injury. And even Mills notes that in its decision. So moving on to the element of a material misrepresentation. Plaintiff has made a lot of the fact that they have an expert who says that this omission is material.
Which omission are you talking about? Because
The omission of the May 2018 cash flows from Piper Jaffray's discounted cash flow analysis.
So you don't
His
concede
argument
that
in his
the-
complaint.
You don't concede that the theory is a little bit broader in the sense that he's arguing that the earlier omitted cash flows were part and parcel of the misleading statement here.
He does argue that. He has no evidence to support that, but he does argue that.
What do you mean he has no evidence? I thought the
Well-
district court engaged with that.
His expert never opines that the November 2017 cash flows should have been disclosed in the proxy. That is nowhere in the record.
You need an expert for that? I mean, it seems intuitive to me that an investor would want to know if the same advisor who advised the board as to the final, quote, final projections had, what was it, 3, 4, 5 months earlier, calculated a completely different discounted cash flow. I mean, that seems relevant to a reasonable investor.
Well, superficially, I can understand that reaction. The testimony, the evidence in the case is that first, those cash flows, the November cash flows, were done as illustrative, and it was not a rigorous, discrete financial analysis. They were just something that the Piper people came up with on their own with no input whatsoever from First Connecticut. They were not engaged by First Connecticut at the time. They were not considering the merger transaction that is at issue in this case. That transaction wasn't even on the table and hadn't been announced when they did those projections. It was not submitted to Piper Jaffray's Fairness Committee that does an analysis of whether the cash flows and all the financial inputs are proper. It was not for the people's merger, as I mentioned. It was, his testimony says, Mr. Hutchinson, who was the Piper person who did the analysis, said that was 7 months before. It was not comparable to the cash flows that we used in the merger, and it was a specific moment in time. And if you look at the proxy statement itself, it says this valuation is as of June 2018, and it is only valid for that point in time. So the November 2017 cash flow projections are a red herring. I know they're more. I know they want to use make much of it, but even in his expert's own analysis, own valuation, the $3 more that he says, he doesn't even use the November 2017 cash projections. He has his own cash projections that he uses. So when he gets that higher number, that is not, that's not a number that came from Piper or First Connecticut. And by the way, in the proxy itself, one of the 3 stock price analyses that it does gives a stock price that's even higher than the one that plaintiff's expert gives when he says it was $3.18 more. The proxy itself gives one that's $3.25 more than the actual value. So it's not like the shareholders didn't know that it was possible that the potential per share price value was what Mr. Keith says it should have been. So that's why the November 2017 projections aren't relevant to whether the cash flows that were actually used in the projections, and even if they were somehow relevant, which they're not, there's nothing that suggests that, and in fact, Mr. Hutchinson testified, he never downwardly adjusted the cash flows. They have no evidence that contradicts that. So, what could possibly be misleading about this case? This own court has held in Willis Towers that it can't just be an omission. It has to be a misleading one. And Mr. Keith never says that the omission was misleading, the expert. There's no evidence other than Mr. Keith's expert on materiality. His own plaintiff, as the court has noted, didn't even read any of the sections we're talking about before he filed suit. So the expert never says that the Piper cash flows were wrong. He says that the Piper cash flows were, or Piper's analysis was flawed, that it was deficient because it didn't contain the cash flows. He quibbles with the inputs that Piper uses for the cash flows, but he doesn't say that the valuation that they came up with in their cash flow analysis was wrong. He just said he doesn't like them.
That appellant didn't have the opportunity to file the pleading in opposition to the motion for summary judgment before it was ruled upon.
Right. We've heard what plaintiffs say they would have argued if they hadn't done what they did, or if the judge hadn't done what he did. Putting aside whether he could have excluded our expert, he had plenty of time before that decision was made to file a motion to exclude the experts. He could have done that in his own motion for summary judgment, like we did. That's when we filed our motion. He had that time. And beyond that, he could have done a motion for reconsideration. And he put forth a couple of things that he would have said differently, but that does not deal with materiality, that doesn't deal with the misrepresentation issue, nor does it deal with loss causation.
Do you have it, I mean, this is, it's unusual for a district court to do this, to have a scheduling order and then grant summary judgment before the opposition brief comes in. Do you have any idea what happened here?
We're good advocates. I mean,
I was just wondering whether, and I can ask your colleague the same thing. This is an unusual procedural posture we find ourselves in. So.
Yeah, obviously we agreed with the court's opinion, and I think you look back at the record and everything, all the transcripts that he's talking about were already there. They had been submitted. So I don't know what he's talking about when he says the depositions weren't in front of the court. All the information was there for the court to use and decide. Can I come back to one thing, because I think I misheard you on a question that you asked? On the transaction causation, I only mean that they have satisfied the element of the transaction causation.
That's the part where the proxy causes the transaction.
Right.
But you are not
Right.
conceding
That
that
there
if
was
for
loss.
loss causation, all you have to show is that the merger caused the loss. You're
Yes.
not conceding that they can show that.
My colleague Tim Fitzmaurice was
Thank you. Okay.
feverishly
I'm
writing
sure I
an email
asked the
about
question
that.
wrong. Thank you.
wanted to just
I was
point that
surprised.
out to
Okay.
you. Okay. A couple of other points on materiality. Their argument was material omission, and they would have gotten a higher value. Well, the undisputed testimony is that People's Bank, the acquirer, would not have paid a dime more or a penny more per share of stock. So unless they have something to dispute that, and they don't even have a competing bid, they don't have any evidence that there was anybody objecting to the omission. None of the analysts, and there were a bunch of analysts. So analysts are like reporters for companies, they're the paparazzi of the companies. Nobody was commenting on the lack of omission of the cash, or the omission of the cash flows. Not one person said it. The shareholder vote was almost 96% in favor. The ISS, which is one of the, it's the Institutional Shareholder Services, they recommended the merger. None of them had any complaints, and that's really a quite significant thing. I mean, companies wait and with bated breath to see what the ISS is going to say, because that can be an important approval of the merger and its process. And if anything, analysts were saying, well, People's stock, the acquired stock, went down, so it looks like they paid too much for First Connecticut. It was a substantial premium over the actual share price. There's no evidence that the share price that they are arguing should be the share price was ever achieved by First Connecticut. It had never gotten that high in the whole history of the bank. All right, negligence. This is not a car rear-ending another car. This is a case where the question is, would a reasonable director raise their hands and say, hey, in this 180-page proxy, I notice that there's one line item of cash flow projections missing, and gosh, shouldn't we evaluate those and include those? The ordinary person walking around on the street is just not going to have the answer to that question, okay? PhDs walking down the street are not going to have the answer to that question. Most business people would not have the answer to that question. So plaintiff has to explain to us for a negligence claim what the standard should be and how they should meet it. And plaintiff puts forth zero evidence. His expert doesn't say it. His expert doesn't put forth the standard, nor he never asked that question of any of the defendants or their experts, and his class plaintiff didn't read it and doesn't even know what it said. So there's just no evidence there. And the plaintiff argues that there should be, that's the decision for the judge. That's just not true. There are a number of cases that make clear that you have to put forward the negligence standard if you're going to make a claim, or you have to put forth evidence of the standard to put forth and negligence. Plain. Shanahan and Ginder are the best examples of that. So, in general, at best, what plaintiff argues and what he said he was going to put forth in his reply is that they should have known to identify this one line in the 180-page proxy. One line from 3 separate evaluations. That's just not enough. And therefore, for all the reasons that I identified, this case should be dismissed. Oh my. Any further questions? Thank you very much.
Thank you, Mr. Long. Mr. Monteverde, you have some rebuttal.
Sure. I'll try to address the points in the order he presented them. On the loss causation, I think it's important to understand what Dura says and what Dura doesn't say. And the reason we make the distinguishing issue, that was a 10b-5, is because in 10b-5, what are you governing? Or what are you trying to exert oversight over is the buying and selling of a stock in the public market based on a misleading statement. And what normally happens is if a company is lying about its revenues, the truth emerges and then the stock plummets. That's a traditional 10b-5. In a merger case, that is not the conduct that we are trying to supervise. It's not the buy or sell of the shares, it's the solicitation of the votes. It's a very important distinction. That's why Dura itself, the Supreme Court said, we're not saying this is how you prove economic loss in other contexts. They say that. They are self-restraining to that circumstance. In a merger case, the conduct we're trying to govern or police is soliciting votes. If you're going to solicit votes with a misleading statement that then causes the merger, and the merger is for an unfair price, and a plaintiff can check all those boxes, you have damages. That's what Virginia Bankshire said, that's what Mills said, and that's what the Baum versus Harman International opinion, that's a district court opinion, I recognize that, but we did submit supplemental authority on that point, said. And it makes sense because this is a merger, it's not a fraud on the market. So that's a distinction I ask that you consider because it's a relevant distinction. And then our expert, Mr. Kidd, says the shareholders were damaged $3.18 because the merger was unfair. They could not get the merger approved if they didn't get the solicitation of the votes
Does it
without a
matter,
misleading proxy.
Mr. Monteverde, as your colleague on the other side says, that there's just simply no evidence that there was any other willing bidder and no evidence that the company that bought the shares was willing to pay anything more.
Well, I have 2 responses to that. One, then you don't sell. It's like if you want to sell your home, Your Honor, and you're not getting a buyer that's willing to pay what you think is fair price, you don't sell. They're not required to sell. It's not mandatory. And 2, I've never heard of a buyer.
Is there any evidence, and if they hadn't sold, then what would the price of the stock have been? Wasn't it at like 26 or something?
Yeah, but
Okay.
if you have a product
Well, then
that
doesn't not selling, if they hadn't sold, then the stock would have been worth less.
maybe, but it's intrinsic value. I mean, I'm not going to suggest.
But we know what it's trading at, and is there any evidence that there was something like glitchy in the market and it was undervalued for some reason?
I don't have any evidence, but under that theory,
Sorry,
then
it's not alleged or anything. You're right, I'm not asking you about that.
it's alleged that the company is worth more money. But I'm not alleging that we can obtain that more money tomorrow. And that is not how these cases are valued. I mean, that's the whole point we have. Also, by the way, if you're not disclosing to the market your true projections, I don't know how the market can actually properly value you. So we have a lot of problems there, but these are material disputes. They're not issues for summary judgment. And the issue that the buyer was unwilling to pay more, I've never heard of a buyer coming to the deposition to say, yeah, I would have paid more if they asked me for more, to pay more.
What was not in front of the court at the time the district court ruled on the motion for summary judgment that you would have included in your opposition? What was not in front of the court?
I think the most important would have been our Daubert motions to exclude their experts. And by the way,
As opposing counsel pointed out, you could have filed your Daubert motions.
we could do many things, but strategically, normally, we move for summary judgment. Defendants responded, then they tried to divert our expert. I have no thinking they're going to use their experts or move for summary judgment. I don't know if they're going to do it or not. After they move for summary judgment and they divert my expert and they put their experts forward, then I will respond and divert their experts. I mean, that is just traditional litigation steps. And I don't think we can be chastised for not, guessing. We might have guessed correctly, but guessing that they were going to put their experts forward. And when the trial was not scheduled yet, we normally don't do divert motions until either at summary judgment or after.
I am struggling with this, and I do understand what you're saying about, but then he just did it, and then he closed the case. But it just seems so odd to me that, not odd, why you didn't move to reconsider and say, hang on a second, we need to Daubert their experts. You forgot that part.
Maybe I should be more naive and think that he might have changed his mind, or maybe I'm too jaded. It is what it is. We made a strategic decision that we didn't think we would be able to, the way the judge acted. I've never seen this before. So when someone does something that is completely out of norm, we got to change
Just seems like
tact.
it could have been an oversight, I didn't know you had Daubert motions you wanted me to look at. Sure, okay.
Okay, but we are where we are today. And my expert at 8/12/17, which is important, 8/12/17, he says proxies regularly include, and it's customary to include cash flows. They didn't have them. It's a problem. And then we found out in discovery, probably the reason is because they manipulated them. And they didn't want the shareholders to find that out. And they could have not obtained a fairness opinion, and shareholders at the end of the day, they got shortchanged.
Your expert opinion was in front of the district court? Your expert's report was in front of the district court?
Yes. But when someone opposes you and you want to respond, sometimes you can redirect the court or explain to the court it's there, and this is how that helps here. We didn't get to do that. Procedurally, I think this case has to be remanded. What we're suggesting is not only remanded, but it be reassigned so we have a fresh set of eyes, which I think it's appropriate request here. And frankly, it's unfair to force a judge to reconsider things that he clearly has already made his mind up on. Thank
All right.
you very much.
Thank you, Mr. Monteverde. All right, we'll come down and greet counsel and move on to our next case.
Thank you very much.
Torres versus Ball. Mr. Harawa, welcome back.
Good morning, Your Honors. May it please the Court. It's always good to be back. I get to sit down today and introduce third-year law students at NYU Law, Zach Sanders, Sophie Spears, and Daniel Cook. Ms. Spears and Mr. Sanders will be arguing under my supervision. Thank you.
Very well, thank you. Welcome. Mr. Sanders, whenever you're ready.
Thank you, Your Honors. Good morning, and may it please the Court. Zachary Sanders for the appellant, Jonathan Anthony Lee Torres. I'm reserving 7 minutes for rebuttal, from which you'll hear from my colleague, Sophie Spears. Mr. Torres' Section 1983 suit against Sergeant Nathan Ball presents critical questions under the Fourth Amendment, which must be resolved by a fact finder. The district court erred in evaluating Sergeant Ball's motion for summary judgment in 2 critical ways, and each of these errors independently require reversal. First, extant questions of material fact and questions surrounding Sergeant Ball's credibility precluded a grant of summary judgment in Sergeant Ball's favor. The open, factual issues in this case go directly to the question of whether or not Sergeant Ball had reasonable, articulable suspicion to pull over the green Honda. By drawing inferences in Sergeant Ball's favor and by ignoring the inconsistencies within his police report and litigation affidavit, the court both violated the well-established dictate to draw inferences in favor of the non-moving party at summary judgment, and it impermissibly made credibility determinations. Assessing credibility is the paradigmatic jury fact-finder role, and the district court's improper assumption thereof requires reversal. Second, the district court failed to conduct...
Credibility determinations were made that were improper in your estimation.
So, Your Honor, the district court ignored the inconsistencies between his police report and his affidavit. From the initial contemporaneous police report to the affidavit, Sergeant Ball added critical...
Can I ask you to slow your speech down a little bit?
Sure, I apologize, Your
I have
Honor.
a hard time following. Okay, go
I'm sorry,
ahead.
Your Honor. So, between the presentation of the contemporaneous police report and his litigation affidavit, Sergeant Ball added critical details which were relevant to the reasonable suspicion inquiry. And that's the underlying law to which these facts are material. The fact that he added details from the initial police report to the litigation affidavit go directly to the question of whether or not he had reasonable articulable suspicion to pull over the green Honda on the morning of March 3rd, 2018.
So, I'm sorry, is your argument that, right, there are additional details in the affidavit? Is the idea that the judge should not have treated those as credible? Is that the idea, that because they weren't said the first time, they are likely not true?
Your Honor, we're not necessarily alleging that one way or the other.
Is there like a factual, on some of them, I'm trying to figure out, I guess, sort of why this matters.
Sure.
Like, is there a dispute of fact, say, like, you know, we're on summary judgment, and I understand that your client would have been, you know, had sort of limited insight to some of these issues, but is there like a real dispute of fact in this case as to say whether this confidential informant had provided reliable information in the past?
Well, in fact, Your Honor, we don't know anything about this confidential informant. There's absolutely nothing on the
Understood,
record.
but usually, like, the usual rule is the police officer submits the affidavit,
Mm-hmm.
he swears to it, like, we assume it's true unless there's some good reason not to. And I guess I'm asking you, is the point behind this kind of credibility argument that actually the district court erred in treating that as true?
Yes, Your Honor, that's exactly what our argument is. The fact that these details were added initially and the fact that they were critical to the determination of reasonable suspicion, we think is directly material to the question of whether or not Sergeant Ball had reasonable suspicion to believe that Mr. Torres was the driver of the
So
green
at
Honda.
trial, the idea is that if summary judgment had not been granted, then at trial, you guys would get up and say, no, the officer was lying when he said that. This confidential informant had never provided reliable information in the past.
Well, we certainly would leave it to the jury to make that determination, Your Honor. But our argument is the fact that we don't have any of those indicia of reliability that the court usually relies upon to determine whether or not an anonymous informant is reliable or not. The fact that we don't have anything.
But that's a different argument.
Sure.
That's sort of even assuming the affidavit maybe. But I read this part of the brief and I understood the points I think that you were trying to make. I didn't quite understand the import, like where you wanted us to go with this idea that there seems to be more detail in the affidavit than there was in the original report, which struck me as not that unusual. Like, you know, it's not inconsistent, it's just there's a little more information once you sit down to write your litigation affidavit.
Sure. Your Honor, I understand that on their face the details may seem somewhat semantic or, you know, maybe.
Just that it's not that surprising that, you know,
Sure.
you write out your first report and then, like, it's not necessary, it doesn't, I don't think we usually treat it as bearing on an officer's credibility if, say, at the suppression hearing, they get up on the stand and they have more detail in their account than they had in the original police report.
Well, the problem, Your Honor, and this is the reason why I started to get to the argument about the anonymous tip and the details we have, is because these details go directly to that question. They go directly to the question of whether Sergeant Ball had enough information to connect the information that he had in his tip directly to Sergeant Ball being the driver of the green Honda that he saw. All we know about this confidential informant is that it was someone that he relied upon, to quote more directly, it was a reliable confidential informant from whom he has received reliable information in the past. Across various precedents of this court and the Supreme Court, this court has never deferred merely to an officer's say-so that a confidential informant is reliable. There always is something more in the record, like, for instance, testimony as to how many times the informant has provided reliable information, or specific cases where the informant has provided reliable information without revealing the informant's identity. That's not necessary.
What about our decision in Bynum, which seemed to sanction sort of just a blanket statement from an officer that this is someone who's reliable, who's provided reliable information in the past, full stop, that's it. And we apparently said that was good enough there.
I'm not sure that we read Bynum that way, Your Honor.
Tell me how you read it.
Well, we read it to say that the officer needs to have more, that we need to have more than just the officer's say so. And we know of.
Well, here's the money quote, and you tell me what the majority opinion says this. Although certainly it would have been preferable if the agent had expressly stated in his affidavit the basis for his statement as to the informant's reliability, he did at least swear to the magistrate that he was relying on a known and proven confidential source, not a never known, never verified tipster. Isn't that what we have here?
No, Your Honor, we don't believe that's what we have here. Because if I'm remembering the facts of Bynum correctly, and I apologize, I'm a little bit hazy on the specific facts, but there were other things that the officer did after relying on the tipster to corroborate the tip. And Sergeant Ball didn't do any of those things here.
I'm sorry, just before we move on from this, I thought, like, the cases you cite for this are cases where the officer just says he's reliable. And this one does seem different to me. Here the officer saying he's reliable. Oh, and you want to know why I think he's reliable? Because in the past he's provided me with reliable information.
Mm-hmm.
And I, much like Judge Diaz, I had trouble finding a case of ours saying that that's not enough.
Well, Your
There
Honor,
are cases where there's been more. I agree with you, and the more the better, no question.
Yeah.
But I couldn't find a case saying that that's not enough. And it does seem to me that that is different from just per se, look, trust me, I'm not telling you why, but he's reliable.
Sure, Your Honor. So the reason why we also haven't been able to find a case that says specifically that's not enough is because in all the cases we found, there's been more. In all the cases, there have been more details in the record about, for instance, even there, Supreme Court case, McCrae versus Illinois, where the officer testified specifically as to the number of times he'd relied on the informant, and specific cases where the informant's information was deemed to be dispositive. And there simply are the only case that we were able to find where an officer's say-so was the only thing that was in the record before the officer went and made the investigatory stop. It's a North Carolina Supreme Court case, State versus Hughes.
No, that one's different because that one was just he's reliable. It didn't even go on to say, and the reason I know that is because in the past he has given me reliable information.
Well, either way, in that case, the officer actually went and did even more than Sergeant Ball in this case did. It was in the middle of the day. The subject of the investigation gets off a bus stop where the informant said that he might get off a bus stop. He got into a car, as the informant said he would, and he started driving. The problem there is that there wasn't enough corroboration. The officers pulled over the car before the car got off, if I understand it correctly, the highway divides at one point, goes one direction or the other. If it went in this direction, the tip is corroborated. Went in this direction, the tip is not corroborated, and the officer pulled him off before he got to that divide. So he was never able to corroborate that detail that he was heading in that direction. And that predictive quality of the information is something that has been deemed dispositive, particularly by the Supreme Court in the Alabama versus White case, where the tipster said that there would be an individual who was leaving from a hotel at a particular time, driving a particular car, carrying a briefcase that would have drugs in it, and would be driving to a particular location. And that's exactly what happened. The officer didn't conduct the investigatory stop there until the subject actually was driving in the direction of the hotel. And that predictive...
Don't we have some of that here? I mean, some predictive... it turned out that some of the things the tipster said were in fact accurate, right?
So accuracy and predictive quality, we believe, are two very different things. The fact that Sergeant Ball went to the address that he had and he saw the car there does nothing to connect those two pieces of information to Mr. Torres. Predictive content would have been, for instance, another address that Sergeant Ball had on file for Mr. Torres was 45 Edwards Road. And in fact, that's the address that he received in the ComStat presentation. If he had waited for the car to pull out of the driveway and then drive to 45 Edwards Road, and he saw the car went to 45 Edwards Road, then we'd be within the Alabama versus White situation.
I don't get that. That seems like, in your hypothetical, there are three pieces of information, and you've corroborated that all three of them go together. In this case, there were two pieces of information, and the officer did corroborate that they would, they would match up.
But he didn't corroborate, there was nothing that he did to corroborate that the individual getting into the car or driving away was Mr. Torres.
But that's White too, where in White they say, look, you didn't corroborate what really mattered about this tip, which was that he's doing anything illegal. They're like, right, the ultimate point of the tip you were unable to corroborate, but that's fine. And this seems just like that to me. You weren't able to corroborate, you were right, the ultimate point, that the person who is associated with these two things that go together, the car and the house, is the guy you're looking for, but you were able to corroborate the rest of it.
Well, the difference here, Your Honor, is that here the tip was just alleging Mr. Torres' identity. He was just, the tip was just alleging that Mr. Torres would be the person.
And I should also, I'm sorry, just before we leave Alabama
Sure.
versus White, that one was, if I'm remembering right, a completely anonymous tipster. And here, like putting to one side all the reliability stuff, this is a known person. This is not an anonymous tipster. This is the officer's confidential informant, and if he sends him up to the top of the mountain at 3 a.m. for no reason, there's going to be blowback. So this is a very different kind of case, I think.
Well, I respectfully, Your Honor, I disagree with that characterization because this tipster didn't send Sergeant Ball to the mountain at 3 in the morning. He just sent Sergeant Ball to the mountain. He didn't say he would be there at 3 in the morning.
He sends him to the mountain for no reason.
Well,
There's
but
gonna be blowback.
the reason I make the point of saying that is because if he had said, at 3 in the morning, you're going to find Mr. Torres in the driveway, or early in the morning, you're going to find Mr. Torres there, that would be a different case. That is the predictive quality that this court has found dispositive. In other cases, the fact that predictive quality shows an intimate knowledge of the subject's affairs, and we just don't have that here. Again, there's so many other things that Sergeant Ball could have done to find either that predictive content or satisfy one of the other indicia of reliability, and he just didn't do that here. And I'm sure my colleague on rebuttal will get to what some of those things are, but for now, I see my time has expired. So just to conclude briefly, if Your Honors don't have any other questions, I'd like to just reiterate that both the extant factual questions as well as the district court's misapplication of Fourth Amendment case law militate strongly against summary judgment in this case, and we respectfully ask this court to reverse, remand, and allow this case to proceed to a fact finder. Thank you, and I'll leave the rest of our time to Ms. Spears on rebuttal.
All right, thank you, Mr. Sanders. Mr. Ingersoll?
Thank you, Your Honor. And if it pleases the panel, my name is Mike Ingersoll, and I represent defendants in this matter. As the panel is clearly aware, in no small part due to, frankly, very good argument by my opposition, this case involves a investigatory traffic stop that took place in Buncombe County, North Carolina, just outside of Asheville, March 3rd, 2018, a little over 5 years ago. That night, Sergeant Nathan Ball, a 20-year veteran of law enforcement and at the time had over 16 years of law enforcement experience, was on patrol in Buncombe County, acting on a slew of information he had in addition to a confidential informant's tip, which we've already addressed. Sergeant Ball,
What was the information he had in addition to the tip? If we take away the tip, what is left of the information that Officer Ball had?
Thank you, Your Honor. So what do we know Sergeant Ball knew at the time of the stop? Because under Terry, Ohio, reasonable suspicion is based on totality of the circumstances and on what the officer knew at the time. So at the time, Officer Ball knew that he knew who Jonathan Torres was. He knew what Jonathan Torres looked like. He knew where Jonathan Torres could likely be found, and that was from two sources. One was Detective Eric Taylor, who was the detective supervising and overseeing the warrants that were out on Mr. Torres. And then the other was the 130 Flat Top Mountain Road address, which he got from the confidential informant.
But we're just talking about not the confidential informant. So he knew the Edwards address and what he looked like and that there were warrants out in an attempt to locate.
Yes, right. And he also knew his criminal history. So, and he knew that criminal history.
I'm sorry, I just want to make sure. He didn't have this address, the mountaintop address, from anyone but the confidential informant, right?
That's correct,
Okay.
Your Honor. Yes. So he knew his criminal history. He knew that involved drug offenses, weapons charges, violent crimes.
Yeah, but without the confidential informant, was there anything that would have made him think the person in this car, when he pulled it over, was the person he was looking for?
I've thought long and hard on that question, and I think the answer is no.
Okay.
And I concede that because I don't think there's any dispute here that the confidential informant tip is the connective tissue here. Sergeant Ball would have never been at 130 Flat Top
It's the
Mountain
sole
Road.
ground you have for reasonable suspicion that when he pulled that car over, the person in the car was Mr. Torres.
I think it's the sole grounds we have for reasonable suspicion that the car was Torres's, and then ultimately there was corroboration that Torres was the one driving, and the reason he knew it was Torres driving was because from the Comstat meeting, he knew.
It wasn't Torres's, he stole it, or somebody stole it. It was
What?
a stolen car.
It was the car that he was driving, it wasn't what Torres owned, yes, Your Honor.
I'm sorry, but you think that, you were about to say there was something beyond the confidential informant's tip would have told him that when he pulled that car over, Torres was in it, and what was that?
That he knew, something would have told him that Torres was the person driving, and that something was the information he'd received from the Comstat meeting. He knew what Torres looked like. He knew Torres was a male. He knew specific characteristics about Torres.
Did he say, did he say that before he pulled the car over, he saw that the driver was Torres?
No, he did not say that.
Well, then,
It wasn't a well-lit area, was it?
Much hay has been made of that, Your Honor. If you want, in the briefing, there's a lot of discussion regarding topographical information and weather data and things like that. You know, how high the moon was and how much light there might have actually been naturally, and the positioning of where Sergeant Ball might have been. All of that goes to their credibility argument, and they try to make a factual dispute out of that, or at least a genuine issue of material fact to preclude summary judgment. All of that, I think, goes to subjectivity, and reasonable suspicion is an objective test. It's what the officer knew. It's what the officer perceived. The information he had at his disposal at the time. And what Sergeant Ball has said is that he could see the vehicle that was described in the tip, including its specific characteristic of a dark green paint job, dark tinted windows, and then he said in his affidavit that he saw a male figure walking around the vehicle. He knew Torres was male.
The CI information is the linchpin. What is your best case law support for what he said about the CI was enough, that the officer said, guy's given me reliable information in the past, without any details to corroborate how he was reliable in the past?
Yes, Your Honor. So in terms of whether the tip was, assuming that it's a known informant, and we can talk about whether, hypothetically if it was an unknown informant, but assuming it's a known informant, number one, there is no need to specifically identify Mr. Torres before Sergeant Ball pulled him over. There's a case out of the Middle District of North Carolina, United States v. Rogers, that this court affirmed in 2014. The site for that is 583 Federal Appendix 54. In that case, the court held, and this court affirmed, that corroboration of innocent facts as opposed to criminal conduct can be sufficient in terms of corroborating a known informant's tip. In that case, law enforcement officers were looking for guns. It ultimately was a search and seizure case, but they analyzed the stop that was involved also. The officers consulted a known informant. That informant, while he or she may have had biases against the suspect, provided a tip that...
United States versus Rogers?
Yes, Your Honor.
In your brief?
It is not in our briefing, Your Honor, no.
So have you provided a copy to opposing counsel? Or to us?
We have not, but we will provide a copy of that after the hearing, Your Honor. So again...
Counsel Rogers apparently is about corroboration of a tip.
It's about corroboration, but it goes to sort of what has been characterized as like a bare bones tip. And I think that the tip that I'm about to describe in Rogers provided substantially less information than what we have here, and it was deemed sufficient.
Okay, but I thought Judge Thacker's question, and Judge Thacker should correct me if I'm wrong, went to the reliability of the informant and case law. What is? I mean, maybe you're saying we should not treat this informant as reliable, and it doesn't matter because there was enough that was corroborated. But I thought you were arguing that, the officer says he's given me reliable information in the past, and we should take from that he is a reliable source. And is there any authority for that?
That is enough.
Yes, Your Honor. So I would argue that is enough. I believe that Judge Harris, you made the astute point earlier that typically this is how this works with affidavit evidence. There is no competing affidavit evidence. offered by
No,
Mr.
no,
Torres.
the point I was making is that I was making a different point, that, and I wasn't really making a point, it was a question, but it went to whether we should be using basically the affidavit version of the source. And the affidavit version is, this is someone who has given me reliable information in the past. Assuming that that is credible, why is that enough?
I believe the Rogers case is one example of where having officers stating that it was a reliable informant that we knew in the past was sufficient. The corroboration of that tip, obviously, if you backfill it, it lends to reliability. In that case, it was a tip regarding someone, they were looking for guns, that the suspect would have a gun in a camouflage case with him. He may be riding in a blue and silver minivan, no make, model, multiple colors on the minivan, that his girlfriend would be driving, and he may be a passenger in that vehicle when his girlfriend goes to work at, I believe she worked at a gas station. Based on that tip and the fact that it was a known informant who'd provided information in the past, officers acted on it, and they ultimately they saw the vehicle out on a main road. It wasn't a situation like this where Sergeant Ball saw Mr. Torres and the vehicle that was described to Sergeant Ball at the end of a dead-end street at the only house at the end of that street. This was out in public. They sort of happened upon the vehicle. Go ahead.
Yeah, let me just say this. I will read the Rogers case. My concern here, I guess, would be that, he does say, he gave me reliable information in the past, but we don't know, how often. We don't know if he was always right. Maybe he gave him 10 tips and one of them was correct. So yeah, he gave me reliable information in the past, but 9 times he gave me unreliable information. We don't know anything about how the confidential informant himself knows this to be true. Like, did he see Torres in this car at this house, or did someone just tell him, oh yeah, Torres, he's that guy at that house with that car? Like, we don't have a lot to go on here. And given that the tip is the only basis for pulling him over, I want to give you a chance to address what would be the concern here.
Yes, Your Honor, and I do understand the concern. And I think what we talked about earlier was if we wanted to treat this as an unknown informant, it just makes the hurdle a little higher to clear, but it doesn't make it insurmountable here. I believe if we assume and we accept from the affidavit evidence, which again is the only record evidence that we have that would be admissible at summary judgment, as Sergeant Ball testified in his affidavit, it was a known informant who provided information in the past. If we accept that as true, the inquiry isn't over in terms of whether there was, whether on reliability, whether the informant was reliable enough to then provide reasonable suspicion for the Terry stop. But the hurdle is lower. If we assume that if it's an unknown informant, I think there are still adequate facts here. I don't think there's any dispute that the tip happened. So, and Judge Ridinger, out of the Western District of North Carolina, noted in his opinion, I believe it's Joint Appendix 322, you'll see at the beginning of the factual recitation, he makes very clear that all the facts recited therein, unless otherwise noted, are not in dispute. What's not in dispute, I believe, is that the tip happened, and though there may be some argument about the semantics of a couple pieces of that tip, generally speaking, the tip described a dark green Honda Accord, or a Honda car, if we default to the police report. That Honda Accord had a unique characteristic, which was dark green tinted windows. It provided a location, and the tip provided that Torres would be the one driving that vehicle. Not that he owned it, we obviously found out later that he didn't, but that he would be the one operating that vehicle. All of those details ultimately were true. Torres was found in that vehicle. He was found at the location.
You're not allowed to do it that way. You can't reason backwards from what turned out to be the case when you made a stop, right? It has to be what the officer knew before he made the stop.
Yes, Your Honor. And again, I think what Officer Ball knew at the time was he knew what Torres looked like. He knew Torres' tattoos, specific characteristics about Torres. He knew where Torres, he knew his address. He knew specifically where Torres lived based on the Comstat information. He knew.
None of that
was relevant.
I believe Torres' official, I can't remember the specific street address, but I believe it was in Fairview, North Carolina. So he knew where Torres lived. He knew Torres lived in the area. He knew Torres' criminal history from his own independent research into his criminal history. He knew the charges that were against him. He knew he had outstanding warrants.
What did any of that have to do with, the question is, when he pulled the car over, did he have reasonable suspicion that Torres would be in it?
I believe, again, going to Sergeant Ball's affidavit, he states that he saw a male figure walk around the backside of the vehicle that he'd positively identified from the
So are you saying he would have had any male he saw in one of these cars he could have pulled over?
I don't think that
Whatever
it's,
it was, a green Accord or.
it's not that it's any male, but again, reasonable suspicion is determined from the totality of circumstances. Based on everything that Sergeant Ball had at his disposal at that time, he believed that he had Jonathan Torres in that vehicle. And again, identification of the driver of the vehicle, there is case law where identification of the driver of the vehicle is not known prior to initiating the stop, it's just suspected, based on very similar facts to what we have here. There's an Eighth Circuit case, United States v. Shields, which I'll provide to the panel and to my opposition afterwards. United States v. Shields is an Eighth Circuit opinion. In that case, again, search and seizure, but they described the Terry stop that took place. In Shields, there was a warrant out for a Brian Shields. Officers were looking for Brian Shields, and the tip that they
Are you
received.
saying this is another case that's not in your brief?
Yes, Your Honor, this is a case that's not in our brief, but I will provide it to the panel.
And to opposing counsel?
Yes, Your Honor, of course.
Can I, before you get to Shields,
Yes, sir.
ask you how this is at all relevant? So one of the purposes of the requirement of reasonable suspicion and is to ensure that an officer is able to narrow what he or she is looking for so that it doesn't dragnet innocent travelers on the highway. And here we're in a sort of isolated area up on a mountaintop. There's not a lot of traffic going around, and so you've got the officer identifying the car which the tipster described, apparently consistently with what the tipster described. And admittedly, he doesn't identify Torres right away, but does that somehow make it more reliable, the fact that, the surrounding circumstances in which the officer found the vehicle?
Yes, Your Honor, I think it does. I also think what's certainly pertinent here is the fact that, like I mentioned earlier, Sergeant Ball is a 20-year law enforcement veteran, had 16 at the time. Most of that was in Buncombe County. He knew the area, he knew the population, he knew the roads up there. Flat Top Mountain Road.
It's a two-lane road. It's not a highway. I mean, there's not a lot of cars traveling up and down the road. So he sees a car that appears to be consistent with the informant's tip. That seems to me to be relevant.
Well, he sees, I think we can take it one step further, Your Honor. I agree with you. I think that what he sees is he sees a car that matches the tip at a location that the tipster gave him at the end of a dead-end road where it's the only house at the end of that road. Again, being the location that he was given. So there are several circumstances and several facts that Officer Ball knew about the vehicle and then saw a male figure walking around the vehicle that it was reasonable for him, again, under a much lower Terry standard, it was reasonable for him to at least take the extra step of initiating a stop to confirm whether the person he thought was Jonathan Torres driving that vehicle was in fact Jonathan Torres, and of course we know that it was.
Can I ask you a question? So you said at one point, like, look, there's this reliability issue, but even, like, if we just assume this is an entirely anonymous tip, treat it like an anonymous tip, there's still enough here, and I think what you're saying is enough of this was corroborated, it's not the right word, but, corroborated, that he had corroborated enough of this.
Yes, Your Honor.
So even if it had been anonymous, it would be enough. Like, I feel like in most areas, but, this is, even if we don't want to say, if you think of reliability kind of on a spectrum, like maybe this isn't all the way over to sort of a named informant or an informant where you have a huge amount of information about their past performance, but it's also not quite at anonymous. It's sort of somewhere in between. And I think in most areas of the law, you say, like, look, if you're not all the way there, like if you're not at, there's no kind of close enough. If you're not all the way there, just forget it. But it does strike me that reasonable suspicion being a somewhat low, practical kind of a standard, this might be the kind of context where you could say, like, do we have everything we would want on reliability? No, we don't, but we've got something. Do we have, like, the kind of perfect corroboration we would like to have? And we do have in some of these cases where there's a lot of kind of personal predictive information that was corroborated. Not quite, but we've got some corroboration. And when we kind of mush it all together, we have enough for reasonable suspicion. See what I'm saying?
I do, Your Honor, and I agree, and I believe that also goes to a point that Judge Diaz made earlier on the opening, which was, don't we have at least some semblance of predictive information here? And I would say that we do, and that is that the vehicle that the tip, even if an unknown tipster, The vehicle with the specific characteristics that the tipster gave was found at the location the tipster said it would be found at, and it was being driven by the person the tipster said would be driving it.
Well, he didn't know when he pulled him over that it was being driven by, all he
course.
knew is it was being driven by a man.
Of course.
So,
Yes, Your Honor. And I
or
understand.
actually,
your
all
point.
he knew is that, he didn't really know anything. He knew that a man had been seen near the car shortly before at 3 a.m. It went driving past him. So let's give him the man is in the car.
Yes, Your Honor, and I understand your point that there was no positive identification of Torres prior to initiating the stop. Again, our position, and I believe the case law reflects through various circuits, including this one, that that isn't necessarily required. It's certainly something to be considered. If you have it, it'd be great, but we don't hear, but we don't necessarily need it. I see I've got about 3 minutes left here.
Well, then, can I just ask you to address one thing on the, sort of the differences between the affidavit and the investigative report? You know, the one thing that seems somewhat substantial to me was that although the police report doesn't exactly say he stopped Torres because the car was reported stolen, it does sort of imply that. It certainly seems to suggest that he knew the car had been, he called in the license check before he made the stop. And then that turns out not to be right. Like, when we get to the affidavit, it's like, no, I didn't find out the car was stolen until after I made the stop. I mean, that's a pretty substantial change, no? In like the chronology of events? What happened here?
No, I understand that, Your Honor, and I saw that argument in a briefing, and I think, you know, the chronology argument, it makes sense if considered in a vacuum. I think there are other facts, and if you give me a moment here, I'll pull up the police report, but there are other facts that are in that initial police report that appear later on in the report. I mean, if you turn to the very end, for example, and I'm looking at Joint Appendix 126 and 127. This is the reporting officer narrative, what I call the report. The very second to last line, Sergeant Ball's body camera was activated during the traffic stop. That appears at the end. So if we're talking about chronology, it's not like all this happened and then
And
Sergeant
I'm
Ball.
sorry, tell me where you are?
Page 127.
Yeah.
Joint Appendix 127.
127.
Second to last sentence. Sergeant Ball's body camera. was
Gotcha.
activated during the
Right, so you're saying, right, it doesn't say this expressly. It sort of gives a bunch of facts, but that doesn't necessarily mean they happened in that order.
And I think what's also critical here is that Sergeant Ball, both through his discovery responses and in his affidavit, made very clear that he did not know the vehicle was stolen until he called it in after he had already apprehended Mr. Torres. So he admits that under oath in multiple places. Again, his interrogatory responses, his discovery responses were a couple months before he filed his affidavit in support of his own motion for summary judgment. So that story did not change, and he made clear in the discovery process that that sequence of events was.
Where he says Sergeant Ball continued to follow, the registration plate on the vehicle was X, an NCIC inquiry showed that the vehicle was stolen, the vehicle turned into the private driveway. Like, there almost should have been like parentheses around the inquiry showed that the vehicle was stolen. Like, that's just P.S., we found out later it was stolen.
Yes, Your Honor, I will say that I haven't met very many Walt Whitmans in my experience with law enforcement officers. Not to say that they're not intelligent, but they're not employed for their writing skills typically. I do want to make one point about qualified immunity to the extent the panel, is considering it. Qualified immunity shields, and I know my time is running low here, so I'll make this quick. Qualified immunity shields officers from liability for making close calls, judgment calls. It only imposes liability when an officer has transgressed a bright line, and it protects everyone except for those who are plainly incompetent. Sergeant Ball here was not plainly incompetent. I've given you, his work history, his many years of law enforcement experience, and this, I believe, it's one of those close calls. So even if, and I don't concede this, but even if there were a Fourth Amendment violation here, and we get to step 2 of the qualified immunity analysis, I don't believe that the law would have been clearly established at the time for Officer Ball to know that him stopping Jonathan Torres, believing he had Jonathan Torres in the vehicle, stopping Jonathan Torres, and then ultimately what took place after that, the search and the seizure, I don't believe he would have known, with all the facts he had at his disposal, the criminal history, the make and model of the car from the tip, everything from him, the information about Torres himself, and what he observed leading up to the stop, I don't believe with all that at his disposal that he would have known that he's still committing a constitutional violation based on the law in this circuit. And I would represent that qualified immunity should still apply here, that defense should be granted, and the end result to this case is the same under those circumstances. Thank you, Your Honor.
Thank you, Mr. Ingersoll. Ms. Spears?
May it please the court. Sophie Spears for appellant Jonathan Anthony Lee Torres. I'd like to return to actually the first question that Judge Thacker asked my colleague, Mr. Sanders, about whether we're questioning Sergeant Ball's credibility and are we saying that he's lying. And I don't think that questioning his credibility based on the fact that he did, as Judge Harris just pointed out at the end of Mr. Ingersoll's argument, that Sergeant Ball changed his reasoning for pulling the car over. I think that it's pretty clear from the police report that the implication is that the car was pulled over because it was stolen. Then 2 years later, this affidavit comes that alleges the car was pulled over because of this confidential informant's tip, which was included, but now it's been transformed to the center of the appellee's argument as to why they pulled over Mr. Torres. And I think when you take those inconsistent statements, that really makes the reasonable suspicion question a bigger one. It makes the reasonable suspicion that Sergeant Ball had questionable. He can no longer rely on the fact that the car was stolen to justify the stop, and the reliability of the confidential informant becomes much more important. So Sergeant Ball's credibility is in question. We're not alleging that he's lying in any way, but instead that there should be a closer look at not only who the confidential informant was, but also what the tip contained. And when you actually look at what the tip contained, it's extremely vague, and the predictive behavior that it contains that Sergeant Ball confirmed doesn't actually...
Wasn't there discovery in this case?
There was, Your Honor.
So wasn't there an opportunity during the discovery stage for a closer look at who this informant was?
Yes, so our client was proceeding pro se at the lower court level, and he was moved 8 times during the course of this litigation. He was under the impression that he had representation during discovery, and then later found out that the NCPLS, which is the North Carolina Prison Legal Services, was not able to take his case because this alleged misconduct did not happen in a prison. And he found that out, I think, a month before discovery closed. So he was conducting discovery and representing himself from prison, which is why there's such limited discovery. And we ask that the court apply the liberal pleading standard to pro se pleadings. And
Can I ask, you
yes.
said that the tip was vague?
Yes.
And I don't understand that. A vague tip is like if, someone says, this Torres guy is up to some shady stuff. I probably shouldn't try to write dialogue, but you know what I mean.
Certainly.
This is like extremely specific. The officer says, I'm looking for a Torres guy, and he's like, okay, here's his address. Here is literally the address at which you can find him and the car that he drives. That seems extremely specific.
Yeah, so I think what's vague about the tip is that there's nothing about what time he might find Mr. Torres there. There's also no investigation on Sergeant Ball's part as to,
But that doesn't go to the vagueness of the tip, like what Sergeant Ball does or doesn't do.
Yeah,
The tip seems like it gives him everything he needs. Here's where you'll find him. I mean, the fact that it omits a time, to me, I would understand it to mean like pretty much all the time, that's where he is.
The tip is vague because it could apply to anyone. So the confidential informant is saying that this tip is about Mr. Torres, but when you take the information that's contained within the tip, which is the address and the car, just looking at those 2 things and confirming that they are accurate doesn't tell you if Mr. Torres is in that car or not. And that is why it's vague, because the only way that, well, I'll get to that in a second, but one of the only ways that Sergeant Ball could verify the tip is by looking and seeing who's driving the car. Although I would like to take this opportunity to point out that the amount of investigation that Sergeant Ball did was very little, and the investigation that he did do actually contradicted the contents of the tip. So on February 26th and February 27th, he received information that Mr. Torres was residing at 45 Edwards Road. Because we don't know anything about the confidential informant, we don't know when he spoke to the confidential
Ms. Spears,
informant.
Can I interrupt
Yes.
for a second? So obviously, if the officer had seen Torres in the car, we wouldn't be here because he knew who he was. He'd seen a picture of him. So I guess the question is, how much more information and what information do you think the officer would have needed short of actually seeing your client in the car?
So, first of all, whether or not Sergeant Ball actually saw a male walking around the car is in dispute. That is a change from the police report to the affidavit. But secondly, he doesn't allege he doesn't state that he noticed anything about this figure. He says a male figure. He doesn't say a male figure with tattoos. He doesn't say a male figure that's 6 feet tall, 190 pounds, similar to Mr. Torres. He doesn't say a male figure who looks Hispanic, which is Mr. Torres' ethnicity. There's nothing that actually provides any detail about how this male figure looks similar to Mr. Torres. Further, Sergeant Ball could have pulled the property records for 130 Flat Top Mountain Road, and if he had, he would have seen that Mr. Torres is not connected to that address because he already had Mr. Torres' address, which was not 130 Flat Top Mountain Road. And he didn't pull any of Mr. Torres' registrations to see if he was associated. Yes, the car was stolen, but he didn't see if he was associated with any cars. There's no indication that he did any investigation other than driving by 130 Flat Top Mountain Road to verify the information in this tip. And just pulling the car over with your gun drawn and assuming that it's Mr. Torres, the confidential informant could have been calling, if they knew your house and your address and they were a known confidential informant, they could allege that any criminal is driving your car at your house.
Whoa, 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 whoa.
And that would give Sergeant Ball the ability to just pull that car over.
That's something we worry about, I think, more with anonymous tips, right? Because then, like, someone could be up to no good. Again, I don't think there's any doubt here that this is someone Ball at least knows who this person is, whether or not he justifiably knows him to be reliable or not, putting that to one side. Like, if this guy sends him to Judge Diaz's house, he's probably going to get in trouble, right?
Certainly. I will point out that an important factor in considering the indicia of reliability of a tip is whether or not the informant can be held accountable. And in North Carolina, it is not illegal to provide false.
It may not be illegal, but I am confident that if this is
I agree with
Sergeant
you.
Ball's confidential informant, there will be consequences if he shows up at Judge Diaz's
I agree with
house.
you. I would like to continue to answer that question. I see that I've run out of time. So thank you. Sorry, interruption. Okay. In terms of whether or not this confidential informant could be held accountable, so our RAS argument is that even if we credit everything about the confidential informant, there still isn't enough reasonable suspicion because the tip doesn't provide enough detailed information to link it to Mr. Torres. But then when you don't have when you have a vague tip, you need to be able to look to the confidential informant and look to their reliability, look to their record, look to where were they, how did they talk to Sergeant Ball? Did they talk to Sergeant Ball on the telephone? Was Sergeant Ball able to evaluate their demeanor? So the question about the confidential informant isn't even whether or not the confidential informant existed, it's how much can we rely on this confidential informant based on the circumstances surrounding their disclosure to Sergeant Ball. Even if Sergeant Ball could trust them because they're a known confidential informant, we still don't know the basis of their knowledge, and that would lend more credence to the tip. It would be in the appellee's benefit to provide more information about the confidential informant and why that confidential informant is so reliable, and that would make up for how vague and generic the tip is. So if I'll just have the chance to close, we do ask this court to remand and reverse on the basis that Sergeant Ball made inconsistent statements related to why he pulled the car over, the basis for his reasonable suspicion, and he acted on what could be characterized as an unreliable tip just based on the lack of information surrounding the tip and the confidential informant, with doing very little investigation, and the knowledge he did have actually contradicted the tip. And on that basis, he pulled over a car at gunpoint. So we ask that this court reverse and remand. Thank you so much.
Thank you. Thank you, Ms. Spears. Mr. Torres might not have had representation at the district court, but he certainly had able representation here today. I want to thank you and your colleagues and the leader of your crew, Mr. Harawa, for taking on this court assignment, which is really important. Obviously, we couldn't do the work that we do without able lawyers, and in this case, students, to come and represent the interests of justice in this case. And Mr. Ingersoll, I thank you as well for your able arguments. We'll come down and greet counsel and adjourn for the day.
This court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you so much. Thank you.
It's always good to see you, Judge. How are you?